Start. Notice on behalf of respondent dash 1 has been accepted by Chief Standing Counsel, and on behalf of respondent dash 2 has been accepted by Shri V.K. Shukla. Para. Admittedly, Srimati Brijvati respondent dash 3 is dead and her interest is represented through her son Shankar Singh respondent dash 2. The counsel for the petitioner is permitted to make a note against the name of respondent dash 3 as deceased and represented by respondent dash 2. Para. The counsel for the caveator does not propose to file counter affidavit in the facts of the case. With the consent of the parties, the writ petition is decided finally. Para. The writ petition has been filed against the order of Deputy Director of Consolidation dated 16.1.2015 passed in Chuck allotment matter. Para. The dispute between the parties is in respect of the allotment of Chuck on plot number 155 and 154. The total area of plot number 155 and 154 was 2.081 hectare, in which the petitioner was having 1/12 share. The counsel for the petitioner states that an area of 0.180 falls in the share of the petitioner. The petitioner was proposed a single chuck of an area of 0.218 hectare on plot number 155. The objection and appeals filed by the respondents against the petitioner has been dismissed. Thereafter, two revisions were filed by the respondent dash 2 in Chuck allotment matters. These revisions were heard along with connected revisions by the Deputy Director of Consolidation, who by the order dated 16.1.2015 allowed the revisions and disturbed the chuck of the petitioner as well as chuck of the brothers of the petitioner. The total chuck of the petitioner as allotted to him on plot number 155 has been deleted, and in lieu of it the petitioner has been allotted chuck on plot number 42, 54, 55 and 56. The area taken from the chuck of the petitioner has been allotted in the chucks of the respondent dash 2 and 3. Hence this writ petition has been filed. Full stop. Para. The counsel for the petitioner submits that according to the share of the petitioner, he was allotted chuck on plot number 155, which was his original holding, but the Deputy Director of Consolidation was not justified to disturb the chuck of the petitioner on his original holding. He further submits that in plot number 55, the petitioner was having an area of 0.015 hectare, and in lieu of this small area, the petitioner has been allotted entire chuck on plot number 55. Plot number 55 was valued at the rate of 80 paisa, while the plots 154 and 155 were valued at the rate of 60 and 70 paisa. Due to allotment of chuck of high valuation of the land, the area of the chuck of the petitioner has been substantially reduced. The petitioner was having his boring on plot number 155 and therefore allotment made to him on his private source of irrigation. Full stop. Para. In reply to the aforesaid arguments, the counsel for the respondent submits that respondents were also the co-sharer in plot number 154 and 155, in which respondent dash 2 was having 1/24 share and respondent dash 3 was also having the same share. The respondents have planted trees and has also installed boring on plot number 154, and looking to the improvements made by the respondents, the Deputy Director of Consolidation has allowed the revision of the respondents. Para. I have considered the arguments of the counsel for the parties and examined the records. it has not denied that the petitioner was co-sharer in plot number 155 and 154, and according to the petitioner, he has installed a boring on plot number 155 and he was having his private source of irrigation, and allotment made to the petitioner on this plot cannot be said to be illegal. Para. So far as the claim of the respondents for allotment of chuck on plot number 154 is concerned, it is not clear that as to whom this plot has been allotted. In such circumstances, boring as well as various trees planted by the respondents cannot be said to be allotted in the chuck of the petitioner. The grievance of the respondents has to be satisfied from the persons to whom his boring and trees were allotted. In such circumstances, the order of Deputy Director of Consolidation dated 16.1.2015 is liable to be set aside. Para. In the results, the writ petition succeeds and is allowed. The order of Deputy Director of Consolidation dated 16.1.2015, so far as it was in revision number 295 in bracket Shankar Singh versus Brijpal Singh, and revision number 297 in bracket Shankar Singh versus Brijpal Singh is set aside. The matter is remanded to the Deputy Director of Consolidation to decide the revisions afresh after hearing the parties in accordance with law. Para. Last ground, though not addressed during the arguments but taken in memo of appeal, is with regard to amount awarded due to cost escalation. In reference to claim number 6 of the respondents, in violation of special condition numbers 21 and 22 of the contract, bare reading of the conclusion recorded by the arbitrator convinces us that the ground taken in the memo of appeal has been abandoned for want of merit. In our opinion, the arbitrator did not award amount of cost escalation in violation of special condition numbers 21 and 22, but within the permissible limits provided therein. Para. In the end, we should like to place our conclusion that in the present case the appellants have miserably failed to make out any ground enumerated in section 34 in bracket 2 of the 1996 Act. Full stop. Over.